So I'll pass perhaps swiftly to you, Rashmi, to give you perhaps kind of to give the audience a little bit more detail about what's actually in this text and how it's evolved and what it looks like at the moment. So go ahead, please.
So my presentation today is going to last roughly 15 minutes. Next slide. In terms of presentation outline, what I'm going to do actually is first provide a very quick update on what is happening at the multilateral level, because there are some relevant, important developments there. And then I'll be delving more closely into what's happening at the plurilateral process in terms of background, going into providing a very high-level overview of the draft, the content of the draft agreement, and then also just quickly talking about what we can expect next in terms of the legal architecture issue. Next slide. So, of course, it's important to recognize that e-commerce is discussed at the multilateral level. It has been discussed as early as 1998 when the work program on e-commerce was set up. The work program has two objectives. The first is it's a forum in which you discuss issues relating to trade and e-commerce. It's not a rulemaking forum, it's a discussion forum. And then the second objective is it's also the platform through which you decide on issues relating to the e-commerce moratorium, where members decide to not impose custom duties on electronic transmissions and the content that's carried within those transmissions. Now, this moratorium has essentially been renewed every 2 years at ministerial conferences, but there has been an important development that has taken place. At the last ministerial conference, members decided that the work program, which includes this discussion element as well as the moratorium, both of these things will be coming to an end. They will expire at the next ministerial conference in MC14 in 2026. Now, there are two important implications to this. One, well, it's not quite clear how e-commerce is going to be discussed post 2026. But the second element is it's fair to assume that the expiry is likely to influence some discussions that are taking place at the plurilateral level, notably the angle on customs duties. So those are two elements just to keep in mind, and it's key. Next slide. So now let's switch into the plurilateral process. Here, the plurilateral process essentially means that only a subgroup of WTO members are involved, not all 166 of them. And the objective of this subgroup is it's to move beyond the discussion focused angle of the e-commerce and trade, and to move into rulemaking. So what they're looking to do is negotiate a new agreement on e-commerce through the WTO. Now, because of the number of members involved, this new agreement is essentially going to become a global agreement. It's going to be the first baseline agreement on e-commerce. So it's quite an important development. The negotiations is now entering its fifth year, and with what many assume will be the final year of negotiations, the co-conveners have indicated that they essentially plan to finalize and hopefully deliver this legal text in the coming months, if they're able to align on some of the last remaining issues. So we can really expect a finalized legal text possibly over the summer or later after, if that's the latest. Next slide. Now, in terms of the participation profile, this is slightly outdated. We just got a little bit of an updated scoop now. There's 91 WTO members engaging in the process, in the negotiating process. This represents roughly a little more than half the membership base, which may not be as significant, but it's important to note that the countries who are engaging in them are very economically dominant actors. The trade that occurs between the participating members accounts for more than 90% of global trade. You have countries such as China, the US, and the EU participating in these negotiations. You do, however, have some large emerging markets such as India and South Africa who are not participating, but that's not necessarily because of the content of the agreement, but rather due to their opposition to these recent plurilateral initiatives, negotiations having been launched at the WTO in the first place. There's also like a limited engagement of developing countries in LDCs, especially when you compare it to the other joint statement initiative process, the investment facilitation negotiations. In this case, you only have 5 LDCs. You have no Pacific and Caribbean developing countries. There's very low participation from African countries. If you do have developing countries participating, we found that they typically came from the Latin American and Asian regions. Now, there's one implication to this relatively low participation that is important to take note of. It essentially means that the needs and the interests of developing countries, and from a diverse regional perspectives, there is a risk that these interests may not be adequately captured in this emerging global baseline agreement. So that is one risk to take note of. Next slide. So that's just a little bit on the background. Now what I'm going to do is I'll explain, I'll give a very high level overview of explanation of what's in the draft legal text. I'll just cover the substantive elements, and I'll be covering the latest legal text, which was released on 28th June 2024. I'm not going to go into all the articles, but you will get a sense of what are some of the key elements of this agreement. Next slide. Okay, so section B, this is the first of the substantive sections of the agreement, and really the objective of this section is to essentially promote electronic formats and transactions. And the way it does this is essentially recognizing the legal validity of electronic formats and making those equivalent to paper-based transactions. So parties are essentially encouraged to adopt certain legal principles in the form of UN model laws that essentially provides the same legal recognition to electronic formats, for example, contracts, invoices, information, signatures. You essentially apply the same legal validity that to these elements that you would to paper-based transactions. The other way in which this section essentially promotes electronic formats and transactions is there's a few articles on trade facilitation. And here it's really encouraging the digitization of customs procedures and the use of single windows. E-payments is another article that's also important within this section because, of course, without e-payments, e-commerce transactions can't take place. So there's this element of essentially promoting transparency, and there's also an angle on national treatment that's key here. From my understanding, this is one article that is still under discussion, but Jara can provide us an updated if that's still the case. Next slide. Sorry. So section C, this section is really focusing on ensuring an open electronics commerce. And it includes a whole diverse range of articles. Importantly, this is the section that includes the article on customs duties. In this case, what parties are looking to do is they've agreed to a permanent moratorium where they agree to not impose custom duties on the electronic transmissions and the content that's carried within. So this is quite an important article. In addition to this moratorium, there is, however, a 5-year review clause where parties, after 5 years after the entry into force of the agreement and periodically after, they will be reviewing the impacts of the moratorium and considering whether any amendments are needed. So there is this flexibility that is built into this article. There are other articles that focus on, again, openness, which is ensuring that government public data is made more publicly accessible. There's also an important article in there on legal principles that recognize end users' right to the internet, free from discriminatory and unfair competitive practices. So it's essentially a principle around fair competition. So these are the ways in which openness is promoted. Next section. This section is also very, very important because it recognizes that trust is a very critical element in electronic commerce. It's a transaction that's not face to face. So it's about building in certain regulations, measures, frameworks that strengthens the trust so that consumers and businesses can engage in the digital economy. And there's a range of recommendations here. One, in terms of what types of measures and frameworks that governments should adopt to strengthen this trust. For example, parties are encouraged to put in place, update their consumer policy to address the e-commerce needs. So develop online consumer policies, address the issue of spam, which is where you have third parties accessing your data and sending you advertisements around it. And parties are also expected to put in place a legal framework. So moving beyond just measures, a legal framework that addresses the issue of personal data protection. Cybersecurity is also another important element in there. Parties are encouraged to strengthen the the capabilities of their national entities to address potential cybersecurity threats. So really a range of measures and frameworks that are recommended on strengthening this element of trust. Next section. Section E, this is a cross-cutting issues section. You have you have an article that relates to transparency. It's a publication-related article, typical one. There's cooperation. Parties are encouraged to cooperate on a range of issues that are relevant to e-commerce. And importantly, this is the section that includes the development article. I'm not going to go into a lot of detail here because we have a whole next session that's dedicated to it. But one important point to keep in mind here is essentially developing countries and LDCs are able to access a flexibility in that they have a longer time period they're in which they can implement any of the articles of their choosing. So they have this longer time period of 5 to 7 years if they choose to for any of the articles that I've previously mentioned. So that's very key to important to recognize. Next section. The final section is section E, which is on telecommunications, and really, and this is recognizing that it's encouraging parties to essentially adopt principles that promotes fair competition within the telecom services market. And here, parties are expected to essentially adopt the telecom reference paper, the basic services telecom reference paper, if they haven't done so already. And they're also expected to adopt additional principles in areas of regulatory reforms that would apply to telecom services. Okay, so I mean, in some, this is just to give you a very, very high level overview, but what I'm hoping is you get a sense and understanding of essentially the range of articles and issues that are covered in this agreement. You really see that the agreement essentially encourages the adoption of certain types of principles, frameworks, and measures, all of which that aims to promote legal predictability or fair competition, and importantly, trust in the digital economy. And trade facilitation is also, of course, an important element in here. And the final key bucket, I would say, is the market access component, which comes in the form of the customs duties article. And one point to note here is now when developing countries review this agreement, it really is one element is just to understand, okay, well, are these various principles, frameworks, measures that are recommended in this agreement, how useful is it for the country in terms of wanting to promote and create a stable environment for e-commerce? And the second point is, what is the feasibility in terms of implementation? Is the timeline of 5 to 7 years important? Does it give you enough flexibility to for being able to develop and implement these what many would regard as important measures and frameworks and principles for the digital economy. So that's the key element to keep in mind. It's when reviewing this agreement. Next slide. So in terms of what's next, from my understanding, as I mentioned, the legal text it's at a very advanced stage. There are, however, some remaining issues to be discussed. This issue might be outdated, so I'd be curious to hear from Gerbera just how updated these list of issues are. But from my understanding, there's still the topics of custom duties, e-payments, development, and importantly, dispute settlement. That's another article that's being subject to ongoing discussions at the moment. If these issues are resolved and if parties can then come to an agreement on the legal text, then the next issue that they're going to have to tackle is the topic of legal architecture. Just because this agreement is finalized, this doesn't mean that it's a WTO agreement as yet. For this agreement to be included into the WTO's treaty framework, you actually need the permission of all 166 countries. Now, getting that permission is probably going to be very challenging. The other GSI process, the Investment Facilitation Agreement, has been trying to do that for the last year or so, and it hasn't, and it's the conversation is ongoing. So this is an element that the e-commerce GSI will also be tackling once the legal text has been finalized. Thank you. But I'm happy to talk about the legal architecture element in a little bit more detail if there's any more questions around it.
Okay. No, super, Rashmi. Thank you very much indeed. And I might hand over moderation perhaps to Rashid for the second session as part of this webinar. Go ahead, Rashid.
Thank you so much, Alice, for a wonderful start to the webinar. Always a pleasure to work here. And let me also take this opportunity to welcome the participants. Despite being busy, there are a number of them. And what I'm particularly pleased about, two things. One, many of them are from the capital. So that is always a very good sign. So thank you for taking the time to join us. And also, I am very encouraged to see that several of them are those with whom we have been working. As Alice mentioned at the beginning, while this may be the first webinar under SIDA funding, but we have been doing this work since 2020. So very good to see that some people, even from that time, are here. Of course, some new faces, and all we are looking forward to continue working with all of you in the coming days. Now, we will zero in for a deeper dive into the development issue. Obvious reasons, of course, development is, if not the most, one of the most important issues for developing countries in the e-commerce negotiations. And I believe that it is not only for developing countries, but also for developed countries, and for the sake of the system, having a strong, effective, vibrant development dimension that can contribute to the reduction of digital divide is quite important. So to go deeply into that issue, we have two excellent speakers. Let's briefly introduce them. I'll just introduce them a bit more. I'll start with Deborah. Thank you so much, Deborah, for joining us today. She has an impressive background, have been negotiating agreements of all kinds with all kinds of partners for over 20 years. And then, of course, since 2013, she has been based in Geneva at the Guatemala mission to the WTO as a consular and legal attaché. And during this period, she was also chairing the very important Committee on Agriculture at the WTO in 2018. But perhaps most importantly for us and for today's session, she has been the lead negotiator in the e-commerce negotiations since 2020. And in that role, she also facilitated the small group discussions on development. So probably the most appropriate person to take us deeply into the development issue in these GSI e-commerce negotiations, in the agreement, and what more needs to be done. Deborah, floor is yours. Thank you.
Thank you. Good morning or good afternoon, everybody. And thank you, Rashid, for the introductions. First, I would like to take the opportunity to share with you our point of view and also explain a little about the development text. Let me share a little background about the negotiation process of the development. Guatemala, as a proponent at the beginning, introduced a proposal of implementation period, and we highlighted the importance of development as the main element on the agreement. During, as Rashid mentioned before, I was facilitating the development negotiation text based on the country's proposal on these topics. The text during that year was simplified, but it had a higher level ambition because that is the expectation from the members regarding the development. In January 2024, the co-conveners prepared a shared text under the responsibility, which included text that they consider as a landing zone, as Singapore explained previously. And as a result on this text on landing zone, they have to lower in the level of ambition on development. I will start explaining a little how the development section, that is Article 20, is structured. For example, in the agreement, the countries or the members recognize the importance to strengthening the international efforts to bridge the digital divide and enable inclusive digital economy. There is also recognition from the members of the role on technical assistance and capacity building for developing and LDCs in the implementation of the agreement. The text, I will structure the text in different ways. For example, implementation period, needs assessments, principles, some exceptions, and transparency. For example, for implementation period, the text provides an implementation period for developing an LDCs. Every developing member may self-designate which provision require an implementation period. This implementation period is no more than 5 years. Plus, additionally to these 5 years, there is an extension period of 2 years. So that is why in the previous presentation, we're saying 5 and 7, because it's 5 plus 2 extension period years. But every member that should require this extension period should present a notification to the committee 120 days before the expiration of the implementation period. For example, if the case Guatemala designated a consumer protection required 5 years before finalizing these 5 years, 120 days before, I need to present to the committee to notify an extension that I require 2 additional years, and the reason why I need the extension and the action that I need to complete or conclude to implement the consumer protection commitments. This is, for example, to clarify a little how is the process. Then we have also a paragraph referring to needs assessment. The agreement encourages the member, we can call it donors member because it's easier to not be repetitive saying develop or developing members in position to do so. So I will use donors members to support developing an LDC in elaborate or update a needs assessment. That also the idea of these needs assessments is to identify the gaps in the capacity from the members to implement the agreements. So at the end is every member should define if it requires an needs assessment or not. Regarding the commitment in the text, there is no really a binding commitment on development text. They say that develop or developing members in a position to do so agree to facilitate the provision of assistance and support for capacity building. The text also refers about some principles that, for example, activities to address regional and sub-regional challenges, taking into account some development framework, promote internal coordination. This is some of the principles that we have included in the text. The text also covers some exceptions. That is not exactly some exception, but there is a paragraph referring to the dispute settlement mechanism will not apply for LDCs for a period of 7 years after the entry into force of the agreement, but also it says that incentivate the members to do restraint in raising some concern for LDCs. No, so at the end, it encourages the member to consider some flexibilities to LDC regarding the dispute settlement mechanism. And for developing members that have designated implementation period, they will not be subject to a dispute settlement mechanism during the implementation period phase, plus the 2 additional extension period. Regarding the transparency, there is a first dedicated session of the committee to monitor the existing and the new technical assistance and capacity building programs, including also in this dedicated session, the idea is to review if a member is not receiving a technical assistance. This dedicated session should cover also sharing experience from members, review the implementation of the entire all agreement. And there is something that I consider positive and useful, in particular for countries that require technical assistance, is that the text defines that the committee shall make available online all the information that the members have, like we can call it donors member, have submit about the different opportunities of technical assistance and capacity building programs available for the members, including information from international organizations. I consider this as a positive because that will be useful for the members to identify, for example, which topic is priority and which donor member is providing. For example, if I'm interested to require technical assistance on SPAN. And the idea is that this information available online can define me, for example, if I give you examples, Switzerland has defined consumer protection as a priority, but not SPAN. And Singapore defined SPAN as a priority. I know that I have to go to approach to Singapore because they prioritize SPAN. So at the end, in the practice, the idea is to facilitate the developing and LDC members what opportunities the donors are providing and which topic they have prioritized on technical assistance and cooperation. There is obligation regarding this transparency and information. The developed members shall submit a description of the all relevant technical assistance and capacity building programs. And for developing members that are in position to do so, they encouraged to provide all the information at the entry into force of the agreement. So the idea is that the committee will gather all the information and they will have it online for the use of the members. There is another requirement that, for example, in the case of a developing member or LDC require technical assistance, they should provide and notify to the committee the contact point office per country that will be responsible of the cooperation. So, for example, in the case the donors, Japan is interested to support some programs to Guatemala. They know already the contact point of the person responsible of e-commerce in Guatemala, so it will be easier the communication and to create the linkage between the donors and the recipients. And that's it. These are all the elements that cover all the development article. And thank you. I am open for any question. Thank you, Rashid.
Thank you very much, Deborah. Very clear. And I very much like the way you had kind of made it into different, I think, 6 elements: implementation period, needs assessment, capacity building, principles, exceptions, and transparency, and then provided a succinct and yet clear explanation of what the current article offers in terms of development flexibility. So thank you very much. I'm sure there will be other questions. We should have some time for that. and we will come back to. And let me also ask the participants that your questions and comments are very welcome after the second presentation by Joel. But in the meanwhile, if you already want to start writing your questions, you can do that in the chat box. Or uh, I hope that is possible. No, there is a Q&A part. So please, you can put your questions there so the presenters can come back to after their presentations. So now my pleasure to introduce our second speaker, Joel. He has been advising private sector governments, international organizations for the last 15 years on trade and related issues. He is a counselor at the permanent delegation of the Organization of Eastern Caribbean States in Geneva, which are a number of states, and he negotiates on the behalf of the WTO member states from that region on a number of issues, I think all issues, and he was instrumental in having a rather strong development dimension in the IFDA, the Investment Facilitation for Development Agreement. I'm telling Joel, I'm telling all of them an open secret, so I hope you don't mind that. So pleasure to have you because you follow e-commerce as well. Although to the best of my knowledge, none of the OECS WTO member state is a formal participant, not yet in these 91 countries. So that's why I think your perspective would be also quite nicely complementary to the one by Deborah, because this is one of the non-participating, let's say the WTO members that are not participating. So it would be very useful to hear your perspectives as well from that angle. So floor is yours.
Thank you very much, Rashid, and thanks to Deborah as well for a very comprehensive overview. And I want to thank Alice and Rashmi as well for the invitation to participate in this very important session. I have a few caveats to establish before I get into a very quick reflection on the special and differential treatment elements of the e-commerce JSI. First is that, as you rightfully said, Rashid, none of the OECS WTO members is a party to the e-commerce JSI. We did follow the negotiations for a bit between 2019 and up to about, say, 2020, 2021. And in my presentation, I will sort of explain why there was a bit of a fall away, not just on our part, but perhaps more broadly speaking, on the part of a number of developing members. And I also want to say that I may say a few things which might be sort of expressing some concerns and don't want it to be taken by Deborah or any of the other negotiators as a demonstration of any kind of criticism of the negotiators, because I do want to commend them for being able to do excellent work in a very short space of time, more recently especially. And there's a significant amount of convergence emerging in the text. And so my reflections should be treated with the level of professionalism that and respect that I have for my colleagues. Now, having said that, I was asked to specifically look at two issues. One was, what are some of the expectations and concerns that developing countries and LDCs have regarding the e-commerce JSI negotiations? And there are 5 very quick elements I want to outline. And the first really is a real capacity constraint issue that many developing countries and LDCs face here in Geneva. Very often we have to sort of make trade-offs between focusing on the core mandated legacy issues in the WTO, such as with respect to fisheries subsidies, with respect to agriculture. There are horizontal and systemic discussions taking place on reform of the WTO, including reform of the dispute settlement system, which are very fundamental to our very engagement in the WTO. And so capacity constraints sometimes limit our ability to follow in real time some of the emerging issues in the WTO negotiating agenda, such as with respect to e-commerce. So that's one. The other issue, and this goes to one of the reasons why, as the OECS, for example, we sort of fell away from following the JSI in a very detailed manner, really relates to methods of work adopted, and perhaps things have changed since, but we found it particularly difficult to follow when discussions started moving into small group formats. Those became more normalized as, especially going back to 2021, 2022, and it didn't sit well with us, sort of, especially as non-parties, to sort of show up, let's say, to small group discussions when those were really intended for the parties themselves, which were involved in the negotiations. And so that also raised issues around transparency and inclusivity as well, and did in some ways sort of dampened the mood and even emerging enthusiasm at the time for some of our member states to really be involved in these discussions. The third issue I want to raise, and it's linked to the capacity issue, because, and Deborah mentioned the high level of ambition that was assigned, and you'd note that there were discussions taking place on issues such as source codes at one time, issues around data localization, very technical issues, very heavy issues around telecommunications and all of that. And there are some members in the WTO that have the resources, whether in Geneva or could bring those resources from capital with minimum fuss to engage in a very detailed and in a very sort of expert way on some of these issues. And the reality is that a lot of small delegations simply do not have that level of technical expertise to be able to contribute meaningfully to the conversations as they ideally would want to. The fourth issue relates to, and for us in the OECS especially, because we did an e-commerce and digital trade readiness assessment in 2021, which really demonstrated for us the extent to which we have many gaps to address with respect to a legal and regulatory framework, with respect to digital infrastructure and a host of other issues. And we needed to make an assessment of those gaps and the disciplines which were emerging in the e-commerce JSI to really determine whether participating in these sets of negotiations, and I'm coming to the development package, whether it would allow us to close those gaps and whether our own involvement would benefit from sort of transforming our e-commerce and digital trade landscape. And I have to be frank and say that our assessment, and it hasn't changed, was that perhaps it would be a lot more burdensome for us to sort of participate in this rulemaking exercise at this time, given the kinds of gaps that we needed to overcome and given the relatively low ambition that we saw emerging with respect to the development package, which was emerging. And the fifth issue I want to address, and again, it's following from that last point. For instance, I remember at one time when we were having discussions on development, and there's one developed country in particular that said that their own view of development was that we didn't need to really have a discrete sort of component on development in the agreement, because by implementing the disciplines which were emerging, that in and of itself would have formed, would have created the development dividends that countries would need. And of course, we took a different perspective on that. So these really help to explain perhaps why the OECS, and perhaps it's a similar experience for other developing countries and LDCs in terms of what created some amount of reticence in their own participation in the discussions. Very quickly, Rashid, I want to go on to the second issues that I was asked to address. The first relates to whether the development article serves as an important incentive for developing countries and LDCs to join digital trade negotiations, and what are the concerns and benefits. And I really want to just spend some time quickly looking at the section E of the draft text. And I'm looking at the draft which was circulated as of the 28th of June 2024. So as far as I'm aware, this is the most recent draft. And the first thing I noticed when I looked at the development chapter, and I'm saying this in a broader context of a sort of emerging trend towards deprioritization of special and differential treatment in WTO agreements. And the first thing I noticed was this very neutral term which relates to development. And you hear a lot of things coming from other WTO members that, and it's not incorrect, because it's everybody has a right to development. But when it comes to developing countries and least developed countries, it is not just development, it is special and differential treatment. And so from an optics point of view, the first thing that is evident to me is the lack of a section, a discrete section on special and differential treatment. So there is this sort of catch-all horizontal sort of section on transparency, cooperation, and development, as opposed to special and differential treatment. If you look at the investment facilitation agreement, or even the trade facilitation agreement, special and differential treatment is recognized, and the chapters are based on special and differential treatment. It's a more neutral approach taken in e-commerce. So that's one. And then I looked at the section on cooperation, Article 19. And again, it's very neutral. For instance, references being made to the parties, and then one has to ask, who are the parties? Is it that these disciplines are to be applied horizontally across all members, or is there any differentiation? And I'm not seeing the differentiation in Article 19, cooperation. Now, if I were to also look at Article 20, development, I think it's, and I have to commend negotiators for this, because I see reference being made to people, supporting ecosystems and infrastructure, as well as supporting people and MISMEs. And I think that's a very, very critical innovation in the text. And so I really commend negotiators there. But then I see a section on Article 20.4, which speaks to assistance and support for capacity building should be provided to help developing and least developed country parties. What it doesn't specify is who would be providing this support and assistance. Am I to presume from a reading of the text that developing and LDC members themselves could be interpreted as being required to provide that support? Or is it that developed members and developing members in a position to do so? And there's some elements of the text that clarifies those things, and there are other elements of the text that do not clarify those things. So perhaps through a process of legal scrubbing, these issues can be resolved. But for now, there are those types of inconsistencies that appear in the text. And it's perhaps also a drafting issue that can be fixed. And I'm going to wrap up soon. The other issue I want to touch on is the issue around needs assessments. Article 20.8, for instance, there's a mention of needs assessment. I do not recall seeing any mention of needs assessment before. So it comes almost like an afterthought in the text, because, for instance, if you look at the trade facilitation agreement or the investment facilitation agreement, very early up in the piece, there are these references being made to needs assessments and members being able to provide support for the conduct of needs assessments as a fundamental pillar in terms of being able to build out the kinds of technical assistance and capacity building needs of developing countries and LDCs. What needs assessments do is that they provide an evidentiary basis on which members can make requests for dedicated and targeted technical assistance and capacity building. And what I'm not seeing is that same kind of flow coming through the e-commerce GSI in terms of a fairly coherent approach to the issue of needs assessments. And so perhaps that's something that can be reconsidered. And even as I close, there's certain things I want to commend. There are some peace clauses in Articles 20.12, 20.13, and 20.14 that provide some grace periods for the application of dispute settlement proceedings. Again, that is very commendable approach, and so that is very good. And at Article 20.19, that speaks to some work that the committee would be required to do to keep under its purview sort of how the development chapter is being implemented. There's a review clause there, which I think is also very, very, very good. And so again, commending the negotiators for that. But in the main, and notwithstanding some very useful elements and a very useful approach to development in some areas, if a developing member or if the OECS members were to look at this development package and assess whether they will want to be parties in an agreement like this, I am afraid that there's an extent to which the development package may fall short of what members' needs and expectations are. And that's just my own honest assessment, notwithstanding all of the very, very important work that all of the negotiators have done on this. So thank you so much, Rashid, and I'm very happy to take questions and comments. Thanks.
Thank you very much, Jörg. Thank you. I think it was very useful. And thank you for being very clearly describing first the concerns in a general sense of developing countries. A large part of that linked to the, on the one hand, very complex nature of the issues, and on the other, the great substantial capacity constraints that many developing countries face. And then you zeroed in looking at the development article now, and then analyzing it from the perspective of the expectations of developing countries like OECS WTO members, and then also using some examples from other WTO agreements and also from the IFDA. So I think that was quite useful and complemented what Deborah had done, which was a very good description of the development, giving also the history of those discussions.